Sharma, Co-Chairman, Bar Council of India and Managing Trustee, Bar Council of India Trust, Pearl First. We are indeed privileged today to be joined by distinguished members of the judiciary and senior mediation professionals whose contributions have been central to the growth of mediation practice in India and beyond. First, it is my honor to introduce Honorable Mr. Justice Purnendu Singh, Judge, High Court of Patna. Your Lordship's presence today adds great value to this program, and we are deeply grateful for your continuous encouragement of mediation as an integral part of the justice delivery system. May I request Honorable Shri D.K. Sharma, Co-Chairman, Bar Council of India, to felicitate Honorable Mr. Justice Purnendu Singh with a bouquet and a shawl. Next, I have the privilege of introducing Honorable Mr. Justice Dr. Anshuman, Judge, High Court of Patna. We are thankful to your Lordship for being with us today and for your thoughtful engagement with mediation as a humane and forward-looking dispute resolution mechanism. May I again request Honorable Shri D.K. Sharma, Co-Chairman, Bar Council of India, to kindly felicitate Honorable Mr. Justice Dr. Anshuman. We now move to the felicitation of our senior mediation trainers from the Mediation and Conciliation Project Committee, Supreme Court of India, whose expertise has been instrumental in shaping mediation training across the country. I first invite your attention to Mr. Surendra Singh, Senior Trainer, MCPC, Supreme Court of India. Mr. Singh has played a key role in mediation training and capacity building initiatives nationwide. May I request Honorable Shri D.K. Sharma, Co-Chairman, Bar Council of India, to kindly felicitate Mr. Surendra Singh. Next, I am pleased to introduce Ms. Pushp Gupta, Senior Trainer, MCPC, Supreme Court of India. Her contributions have significantly strengthened the practical orientation of mediation training programs. May I request again Honorable Shri D.K. Sharma to felicitate Ms. Pushp Gupta. Next, I have the pleasure of introducing Mr. Sachin Jain, Senior Trainer, MCPC, Supreme Court of India. His experience and witty humor, coupled with practical insights, have enriched mediation training initiatives across jurisdictions. May I again request Honorable Shri D.K. Sharma to felicitate Mr. Sachin Jain. I now invite your attention to Ms. Monica Jalota, Senior Trainer, MCPC, Supreme Court of India. Her work in mediation training and dispute resolution education is widely appreciated. May I request Honorable Shri D.K. Sharma to kindly felicitate Ms. Monica Jalota. I now request our faculty members, Dr. Aditi and Dr. Sanya, to kindly felicitate Honorable Shri D.K. Sharma, Co-Chairman, Bar Council of India. We also have the honor of being joined by our distinguished international speaker who is with us live online, Ms. Chiara Tondini. She is from the International Disputes Council and Chief Operating Officer, M Disputes, Italy. Although Ms. Tondini is joining us virtually, we warmly acknowledge her presence and sincerely thank her for taking the time to share her international expertise with us today. May I request the audience to join me in extending a warm round of applause for all our dignitaries and trainers for their invaluable contributions to this program. To formally open this session, I invite Honorable Shri D.K. Sharma, Member Bar Council of India and Co-Chairman Bar Council of India, to deliver the welcome address.
Honorable judges on the dais, distinguished trainers from the MCPC, esteemed international speakers, faculty members, participants, and friends, a very good morning to you all. It gives me immense pleasure to welcome you to training session 3rd of this important mediation program, organized jointly by the Bar Council of India and the Bar Council of India Trust, Pulse First, and the India International University of Legal Education and Research, Goa. At the outset, I extend out my warm and respectful greeting to Honorable Justice Mr. Pushpendu Singh, and Honorable Justice Mr. Dr. Anshuman, who presents today adds great value and inspiration to this program. We are deeply grateful to their continued encouragement of Mediation Center as a meaningful instrument of justice. I also take this opportunity to acknowledge the senior trainers from the Mediation and project from Committee of Supreme Court of India, Shri Surendra Singh, Srimati Pushpa Gupta, Shri Sachin Jain, and Srimati Monica Jalota, who have played a pioneering role in the shaping mediations, practice, training, and institutional culture across the country. Their contribution has been controlled to the growing acceptance of mediation within our justice system. Today's session focuses on mediation's skill in sensitive disputes covering family, child labor, negligence, intelligence, property, and environmental matters. These are areas where disputes are not merely legal constants but deeply human experience. Mediation in such context demand not only technical competence but empathy, patience, and ethical responsibility. The Bar Council of India firmly believes that mediation is no longer an alternative at the margin. It's an essential pillar of contemporary justice delivery. Programs such as this, conducted at institutions like ILUR, are crucial in preparing lawyers and professionals to meet the responsibility with skill and integrity. I am also pleased that session include an international perspective, reminding us that while disputes may be local, best practice is mediation are increasing global. I congratulate ILUR for hosting this program with such commitment and professionalism and I commend the principals. I commend the participants for choosing to invest their time in developing mediation skills that will serve society at large. With these words, I once again welcome all of you and wish the success of every session. Thank you, and I hope you have a rewarding and encouraging learning experience. Good morning.
Thank you very much, sir, for setting the context so clearly and for your continued leadership in strengthening mediation education. It is now my privilege to invite Honorable Mr. Justice Purnendu Singh, Judge of the High Court of Patna, to deliver his special address. Sir, please.
Good morning, everyone. My esteemed brother, Justice Ansuman on DAS, the team of experts here on the DAS, and my esteemed brother, Saurendra Pandey, and my brother Ajit. Ladies and members, other dignitaries, I first congratulate Mr. Madan Kumar Mishra, the chairman of the Bar Council of India, and the vice chancellor of the institution, Mr. Rao, and the students who have assembled here to undergo their training to understand all about mediation, so that wherever they join as a legal professionals or as a educator or they join any of the corporate houses. Now the world is moving towards mediation, that first we should arrive to resolve the dispute so that matter cannot be dragged into the court. Recently, yesterday our Honorable the Chief Justice was present, and I quote the way he has made us all understand what does the mediation really mean. I quote, what the mediators has to do, according to his lordship, is the relationship between the people and different sections of society. And in the words of his lordship, I quote, they choose understanding over victory, conversation over conquest, healing over harm. Courts decide, mediators heal. This ancient wisdom has now found its most common comprehensive legal expression in the Mediation Act 2023. As a judge and the counsels who are sitting here, we face, in respect of today's topic, which primarily relates to family, child labor, negligence, IPR, and environment, etc. So, take a basic example. A husband and wife, they are fighting. They have strained their relationship. As back in year 1992, and after that, the Supreme Court observed that the strained relationship between the husband and wife first they should be allowed to reconcile themselves. If they don't, then certainly their family. If family, then the society. So success was there. So all these cases in respect of the sense of criminality, whether that is there or not, the Supreme Court defined it that such disputes is not against the society. So compromise, if they compromise and they are facing, a husband is facing allegation under section 498A, after the husband and wife has entered into compromise, the criminal prosecution should be kept at rest. Similarly, I will give the references of those cases if I remember later on. Similarly, two brothers in respect of a land, they enter into fierce fight, and one brother has assaulted the other brother has assaulted the other, even the entire family members. Recently, one case I came across where the Supreme Court, taking into consideration of the said fact, perhaps it is Nase Ali. So you can get it on your gadgets. The young lawyers, the young students, they can do that. So Nausea Ali was decided as is in year 2024. There the Supreme Court held that once they want to buy peace of mind, so criminal prosecution should be kept at rest. They should forget, they should bind their relationship, and again live a peaceful life. So situations is there. So behavior of the society, the culture which is developing, which impacts upon the society, has led today different types of litigations. Artificial intelligence, much has been said yesterday. We all listened to that. The threat which has been projected and the threat which we are facing day by day. So how to come up with those? A company is fighting with the other company. So all those issues are there in the society. And who is ultimately impacted by that? It's a single human individual. If we go back and we remember the days which we faced during COVID period, everyone was fear of their life. Oxygen became very important for survival. So irrespective of the culture they belong, the religion they belong, the caste, creed they belong, the only object of humankind was that to save life. When it comes to the threat of human being, the existence of human being, what is important? Today we must remember that day so that we can evolve into a world, a globe, which is bounded by the human kindness, belief in oneness, crossing from the binding of different cultures. And practically we are seeing ourselves. We have adopted English language, we have adopted different dress which was not worn by the people of India at the ancient time. So what is important is to understand yourself, ourself, the basis for which we are here in this world, how we are connected and who connects us. That is very important. So I definitely say we all are Indian. We should be bounded by the very essence of spirituality. The force which exists within us. Once we understand that, the society will become without any offense. There will be a society, one striving for the other. So that is the objective. With that objective, to start with, 2023 Mediation Act came into effect. With that objective, yesterday we heard our Chief Justice and Justice Maheshwari all speaking with that intent. So ultimately what matters is your self-realization so that we cannot harm the other, even ourselves. We should not be putting any threat to our life, to our belief, to our knowledge, so that our act and deeds will not lead to affect any other. If that is understood, and I hope our educator today will bind and will make themselves prepared to teach the students and the persons who are affected in the society faced with different type of problems. So that way, the role of mediators becomes very pivotal. So I was wondering what to speak in respect of this technical session. So in this background, I find that adhering to the norms, the statutory provision of 2023 Mediation Act, we will proceed. The background is oneness. The background is to understand ourselves. The background is to bind with that unknown, the power, the supreme. That should be the present day understanding. I thank you, all of you. I have been provided with very short time. Otherwise, the topic is very vast. So the other speakers will come and experience theirs and share today. Thank you.
Thank you, Your Lordship, for those valuable insights and for reminding us of the judiciary's confidence in mediation, particularly in sensitive and human-centered disputes. I now request Honorable Mr. Justice Dr. Anshuman, Judge of the High Court of Patna, to kindly address the gathering.
Dear participants, I seek your permission to express my views without any formal address due to lack of time. As you know, that mediation is one of the art of resolving disputes, and today's topic is the National Conference and Symposium on Mediation, how far significant in the present day context. Prior to entering into this concept of mediation, I know, due to my experience of teaching in the National Law School and the judicial trainer and member Law Commission for 15 years, that mediation is nowhere directly in the syllabus of law. And it is so easy and so tough also. If you have basic understanding, this topic is so easy. But if you have no interaction, then you feel it that what is this? I share my experience as a lawyer. When 45 days training on conciliation was started, prior to start of the training, we used to think, kya ye padhayenge bhai? And what is the need of that? But when 40-hour training has started and the methodology, the way of resolving dispute has been discussed by the expert mediators, then we realize that, oh, this is one of the way of resolving disputes. And the beauty of the mediation is that not only the dispute resolves, rather the future probable problem and relation between the parties to the litigation also ended. They started living with happy and peaceful life. Means further litigation ended. So this is the beauty. By one successful mediation, there may be series of litigation, 10, 15, 20 litigation is being ended between the parties, which we later realized by way of working an expert mediator. And presently in family disputes, sitting in the division bench in a miscellaneous appeal, we realize that when parties used to appear before us and sometimes they are estranged husband and wife, they do not want to see their faces. They want to see कि इसके सामने मैं नहीं बोलूंगी या नहीं बोलूंगा, इसको हटाइए कमरे से. And in this background you have to work as a mediator. In this background you have to work as a lawyer for the parties. And one thing I just want to share for the lawyers, that at that very time, you are not in adversarial, you should not have to think on adversarial lawyering. You should have to think that due to whatsoever be the reason it may be, the constant developed between the parties, and being the guardian, you have to resolve it. You have to listen them very patiently that what's the problem going on between them, and what may be the probable solution by way of talking individually, by way of talking in presence. And you also must have to realize that what may be the extent of theirs. For example, in 498 cases, the parties or wife or her family used to say, husband को जेल में ही देखना चाहते हैं, किसी कीमत पर जेल ये चला जाए. And you know, the maximum punishment in 1 year, 2 year, 2.5 years, all are bailable. So they will not go to jail, even punishment shall be met. You know, 389, in the court itself they used to grant bail. But anyway, on practical aspect, experts are there. I am just want to share with you the academic aspects of that. The academic aspects, due to the reason that the participants here are basically the law students, either in UG or of PG. Keeping in mind that Mediation Act has come in 2023, prior to that, the word mediation is well known to the judicial system. Then what was the power of the mediation prior to Mediation Act 2023, and after 2023, what has come? And what the message yesterday, Honorable Chief Justice of India, by virtue of plays about which we all fraternity, we all judges and fraternity of law is standing there, and repeat with him for understanding this message. In my view, the thing which I am just going to express to you are necessary. So for students, you please listen it carefully, work on that, and whatever be the questions comes to your mind during discussion in the last, you please write down the question. I will try my level best to answer on those questions, because you know, law atha sagar hai. It is not possible to answer every query, but I will try my level best by virtue of my experience with you. Listen carefully. The mediation is one of the dispute resolution mechanism. In whole world, there are only two ways of resolving dispute. The one is inquisitorial system, and another is adversarial system. America, Canada, and many other countries used to follow the inquisitorial system for resolving dispute. But the Commonwealth countries used to adopt the adversarial system of resolving dispute. We know that adversarial resolving dispute mechanism has been discussed in one of the case 2010 Honorable Supreme Court of India, that is adjudicatory and non-adjudicatory. AFCON India structure case 2010 Honorable Supreme Court has categorically bifurcated that in India adversarial system is applicable, and these adversarial system is basically of two categories: adjudicatory system of resolving mechanism and non-adjudicatory system of resolving mechanism. In the court of law, the adjudicatory system of resolving mechanism, that is in Hindi we can say निर्णयन के तरीके से मैटर को रिजॉल्व करना. एडजुडिकेटरी की हिंदी निर्णयन है. So the method of adjudicatory system used to apply in the Code of Civil Procedure 1908, in the CRPC 1973, now BNSS 2023, in Commercial Court Act 2015, in arbitration, we know that we used to apply the adversarial adjudicatory system. The beauty of adjudicatory system from the practical point of view for the remembrance of the lawyer, in all the adjudicatory system, upon receiving the pleadings, the issue used to be framed, and thereafter the parties used to adduce evidences to decide the issues in their own favor. At the cost of repetition, I just want to share one more thing which is not defined in law or any law books, but it is being answered in our Dharma Shastra, Brihaspati Smriti, the definition of issue. When we were a student, whenever I used to put question to my teachers कि sir ये issue क्या है? What is issue? Answer comes कि ये देखो जो दो pleading आती है दोनों ओर से, दोनों में जो dispute रहता है यही issue है. But by virtue of my experience and my studies reading the book written by Hon'ble Murtagame Ramajoyas, Legal and Constitutional History of India, where he has extracted one shlok from the Brihaspati Smriti and he has defined the word issue, that issues are not the controversy, rather issues are the questions when answered have capacity to resolve the controversy. And thereafter he has made his own comment that member of bar and bench, be careful that at the time of framing of issue you be careful that if you have judicial experience, you may frame one question by virtue of which you can resolve series of controversies. But if you are not experienced, it may happen that by virtue of resolving, by virtue of answering one issue, you may not resolve the controversy. Instead thereof, you have raised more controversy what were already available in the pleading. So, for the purpose of remembrance, I just want to cut short that wherever the adjudicatory method is there, issues used to be framed. And by virtue of deciding the issue, the evidences or materials used to be placed before the persons who is doing adjudication. But so far as non-adjudicatory methods are concerned, the non-adjudicatory method well known is the conciliation, the Lok Adalat, permanent Lok Adalat, and the mediation. So remember a thing, a topic which is the crux of the discussion today. Mediation is a mode of resolving dispute by a non-adjudicatory method. यानी मीडिएशन में इश्यू नहीं बनता, कंट्रोवर्सी नहीं रहती. Now a question is that mediation has come when? In our judicial system, mediation has coming since long, but it has been recognized in section 89 of the CPC by virtue of amendment of 2002, in which every civil dispute has to be decided by virtue of applicability of section 89. Those who are practitioner in civil matters are well known that what are the different methodology in which the matter used to be kept under section 89. After completion of pleading, framing, prior to framing of issue, the court used to put the case को 89 के stage पर रखा जाता है. This is the statement normally comes in the court. Now the question is whether it is sufficient, whether by virtue of writing this, it can be decided that this dispute can be resolved in the mediation, because 89 says that Lok Adalat, mediation, arbitration, what has to be applied, it shall be applied. The answer is no. Because the key, rather the ignition key of beginning of mediation in the CPC is laid down under Order 10. Order 10 is the examination of parties. So until and unless the examination of parties shall not take place, the ignition key shall not be started. So we have to learn the ignition key, that in which way the court or the parties or the lawyer have to ignite the stage of Order 10. Without proper application of examination of party Order 10, the question of mediation shall not arise. Anyway, I am again coming that this mediation, which has been inserted in the judicial system at stage of section 89 in 2002, subsequently the question of mediation further divided in two types. One is the pre-litigation mediation and another is the post-litigation mediation. But here myself, I am hereby correcting myself and correcting to all member of bar and bench that the proper word has been used for post-litigation mediation in the Mediation Act. That it has been given with new name, not as a post-litigation mediation, rather pendatellite mediation. So from today onwards, we shall correct ourselves that there are two types of mediation, that is pre-litigation mediation and the pendatellite litigation mediation. Now, for the purpose of applicability of the mediation, I just want to raise a few topics of Mediation Act 2023. In Mediation Act 2023, certain sections which are very fatal. The first two sections which are most fatal according to me is Section 2H. Section 2H basically defines what is the definition of mediation. And this mediation talks about the mediation either physically or online or electronic mode or digital mode or community mediation. So this mediation has now expanded in Section 2H, and further Section 2J is further important. Section 2J further talks that mediation agreement till date prior to 2023 Act, in almost all contractual agreement, there was a arbitral clause. Mediation Act 2023 recognized the mediation clause in every contract that is now permissible. Number two, that has been defined in 2J, what is the mediation agreement. And it talks that three types of things shall be the mediation agreement. Number one, if this mediation clause which is being inserted in any contract, number one. Number two, if this resolving dispute by mediation has been agreed between the parties by virtue of making correspondence with each other, it shall also come within purview of the mediation agreement. And number three, that if during pendentity of a litigation, the parties file application before the court or shows their desire to resolve the dispute by virtue of mediation, then also it shall be treated as mediation agreement. In addition to that, there are certain sections which are very fatal. Those students, it is requested to them to jot it down. Those sections which are most important according to me, that for the purpose of complete understanding of the arbitral agreement, section 2J should be read with subsection 1 of section 4. The next is concept of pre-litigation mediation. The concept of pre-litigation mediation has been inserted in Mediation Act, section 5. Section 5 categorically talks about the mediation which is applicable before filing of any suit or proceeding, civil or criminal. I am putting emphasis, civil or criminal, in nature, in any court, with exception of section 6, read with first schedule of the act. What the Mediation Act 2023 indicates, that mediation is permissible in civil and criminal proceeding both. Only exception on which this proceeding mediation shall not apply has been collected, section 6, read with the first schedule. Otherwise, according to Mediation 2023, it is applicable to both. Now, I am discussing with you the stepwise procedure for mediation, because I know that reading the law book is one part, but remembering the things stepwise is basically create a scratch in our mind. So, by virtue of proper application of Mediation Act and the oath which has been conducted by us yesterday at the instance of Hon'ble CJI, it is necessary to create a scratch in our mind, and this scratch is as follows. Scratch number 1, step 1. Mutual consent of parties to enter into the mediation, whether pre-litigation or pendentity mediation, both dealt in section 5 and section 7. Second is appointment of mediation, section 8. This is the second step. Third step, the commencement of mediation by receiving notice from party initiating mediation. That is step 3. And time limit for mediation is 120 days. Step 4 is, after mediation, settlement agreement shall be prepared according to section 19 and 20. And whatever be the mediation settlement agreement which has been prepared, it has the effect of decree of the CPC which has been laid down in section 27. The next is, in case of non-settlement, a non-settlement report has also to be prepared according to section 21. And this, in the non-settlement agreement, the mediator shall have to write that it is not fit matter for settlement and settlement is not possible. There is a provision in the Mediation Act 2023 about challenge of mediation settlement under section 28 within 90 days on 4 grounds only. Ground number 1, the mediation settlement if taken place on the ground of fraud, on the ground of corruption, on the ground of impersonation, and on the ground of matter not fit for mediation, yani non-settlement. So on these 4 grounds, this challenge of mediation settlement shall take place before the court. In the background of this, the mediation law of 2023, Honorable CGI yesterday distributed a mediation place for members of Indian judiciary and members of legal fraternity. It is basically the crux of the Mediation Act. What was the legislative direction has been collected by Honorable CGI, and CGI in the form of oath want to provide the Ganna Ras, the mediation Ras for all of us. And in the last, I just want to say that time is less. It has been intimated to me that I have taken more time for you. I am stopping myself. Thank you very much.
Thank you, Your Lordship, for your thoughtful and encouraging words and for emphasizing the transformative role of mediation in today's justice delivery system. We now move to the core training segment of today's session, which is an essential part of the accredited and certified mediator program. I now invite our senior trainers from the MCPC Supreme Court of India to kindly take over and guide us through the training module.
Hi, good morning everyone. You know who is the most worried man in this hall? Dr. Saurav. He was like that you are running over the time. जो रेलवे में एक कहावत है कि the train is delayed, तो कहते रात को कवर कर लेगी. I am that night. We will cover it. Right? Sir, there is a quality, Dr. Saurav, of the mediator. The first thing is patience. He is so patient. एक matrimonial dispute उनके पास आया. The wife was demanding the custody of the child. The husband readily agreed. Then she demanded car. He accepted. Then she demanded alimony. He accepted it. The mediator was curious. Why this lady is not coming to the settlement. So he patiently asked that lady, what else you want, ma'am? He has agreed for everything. So what she told that gentleman, I want nothing, no custody, no alimony, no money, nothing like that. I just want कि जैसे ये mediator साहब शांति से सुन रहे हैं, आप भी मेरी बात शांति से सुन लें. That is the only requirement. So, good news for all of you is that you will be certified for the stage 1, introduction to the mediation today. And the Honorable Member, Suvir Sidhu, has assured us that shortly you all will be contacted by Bar Council of India for complete 40 hours training program. So, you all will be called upon and we will interact completely for 40 hours through the 5-day training program. I'll rest my words here and I'll allow my co-trainers to come over. Thank you. Good day.
So, thank you Surendra ji for actually giving full justice to the time schedule, the way you have crafted your speech. So, taking on further from where our honorable judges, they have laid the foundation for this session. As our honorable judge, Honorable Mr. Justice Pranendu Singh, he said that it's a connection, background connection with somebody unknown. I fully agree and I really connect with his words because in mediation, the mediator is somebody unknown to the parties. And similarly, mediator is unknown about what's gone into the life of these person who are sitting in front of him in some dispute and discord. So as Surendra ji has said, yes, the first first quality of a mediator is patience. If you don't have a patience, I don't think so you can ever achieve anything in your life. These days, with all the struggles, the young generation you are facing, we need patience. But when you are sitting in mediation, since as we've been informed that this is your first step towards the gateway for mediator, being a mediator, it is very important. When you are going to sit as mediator, something which is very important is that you have to shift the spotlight from me to them. If you are going to sit there as Pushp Gupta, who has been brought up in certain setup and has her own views and judgments, then I don't think so you will be able to do justice to the mediation. So when you sit as mediator, you need to listen empathetically to what parties are saying. And what you need is to listen to something which is unsaid. The things which are said through words, it's something which is just visible on surface. But every dispute, so the mediation skill which is required for this topic, it says mediation skills required for any family dispute, commercial, any. The skill required is to listen to something which is unsaid in the mediation. All disputes are between human beings, whether it is labor management, commercial, whether trademark, any industry dispute. Every dispute is ultimately a dispute between two human beings who have been brought up into a different tradition, culture, background. So they have viewed a dispute from a different perspective or lens which is different from the other side. So as mediator, my dear friends, the quality of being a patient, empathetic listener is what is required, whether it is whatever category of dispute it is. You have to just shift to them, listen to them, give them that eye connect, the skill which is again required. You have to give them that eye connect. Your body language speaks volumes when you speak to a person, when you listen to a person. It cannot be fake connect. And as our Honorable Judge, Mr. Anshuman, who is already a trained mediator, the way he has said about when he had undergone mediation training, then he realized, पहले तो सर ने कहा, मैंने सोचा क्या पढ़ाएंगे, पर जब पढ़ाया तो पता चला कि वो 40 घंटे में जो पढ़ाते हैं ना, actually it is so relevant. It teaches you life skills. It teaches you how you have to communicate even with your friends, your family members. और इसलिए मैं बोलती हूँ the Krishna जिनको बोला जाता है first conciliator. If he had undergone 40 hours mediation training तो आज बात ही कुछ और होती. So that is the power of 40 hours mediation training, which can be done only when we have a proper setup, we have proper participations, we have proper curriculum, we have proper role plays, but skills are various skills in mediation training which you are going to gather. So my dear friends, I congratulate you for this journey, and my special thanks to the organizer and especially Dr. Saurabh Kumar and Suvir Sidhu for taking this initiative of including the young generation in these training sessions. And we are with everyone, every member of the Bar Council of India, with our judiciary. And when we say that, as Sir Honorable Mr. Justice Anshuman has said about pendant light and pre-litigation, sir, it's completely the need of the hour, because what today we are looking at mediation is just to take care of the pendency of the cases in courtroom. No. We are moving in a direction when it will be a prevention better than cure. Let it be a prevention that people do not go to the courtrooms for all disputes rather than taking it as a cure. So our journey begins to make it prevention is better than cure, and let us be an extended arm of judiciary and also an independent arm for dispute resolution which has its own identity apart from courtroom structure. So from courtroom to the common public is this, that we have our own journey independent, and we can take mediation as an independent profession also, and the problem of economics attached to mediation as independent problem will soon be taken care of, the way we hold our identities away from courtrooms. Let there be institutional mediations where we have independent mediators, specialized mediators, and my dear friends, the most important, another important skill is that please do not mediate in a matter in which you do not have the basic knowledge about that stream of law. Because if you are going to sit as mediator and if you do not know about the stream of law in that matter, so no negotiations, no bargaining can ever be done by anybody in mediation. It's going to be a negligence which is unpardonable. So let's be like Nokia ki ek line thi. I don't know whether your generation has seen Nokia. So there was a line for Nokia, connecting people. Yes, mediator is connecting people. And we are those unknown people. It's a sacred mission. And it's no less than, it's a medication and a meditation also. So it's an omen service. I am so blessed to be a mediator, and I am a proud mediator, and I look forward that everybody from any field, please go through this 40 hours investment in your life and see how it changes your own self, your own personality, and you become a better human being. We all are human beings, but it's a journey from being human being to being human. So this is what I'll say. There's so much to say, but I have to respect the timings, and thank you all. Thank you so much. My good wishes to each one of you. Thank you so much. Thank you.
A very good morning to all. The time is short, so I'll be very brief in my counterparts. Those who are on dais, they have already shared their views, and I fully agree with them. But there are a few things which I want to address. See, the role of a mediator, and we are first lawyers. We are lawyers first, and then we become mediators. So as a lawyer, we have a much bigger role to play in mediation. We have to understand that it is the lawyer who is the backbone of any judicial system. So as a lawyer, you have to switch your mode, you have to change your button from an adversarial mode to a more collaborative mode. It is only when you collaborate, you have to collaborate with your parties, you have to collaborate with the dispute people, so that you can reach some amicable solution. Now, from changing that mode from adversarial to a collaborative mode, the first most important thing is, before you undergo a 40 hours training, you have to unlearn what you already know. That unlearning phase is very important for every person who takes a 40 hours training. Because that past will haunt you, because you have that experience, you have that knowledge of subject. So what you have to do is you have to leave that aside. Just pull the curtain, start taking a new journey. Once you are on the edge of completing the journey, just open the curtain. Allow that experience to enter, to catch hold up with the new part, and then you will become an excellent human being, excellent mediator. Now, mediation, as my friend Surendraji has said, this is just a beginning. This is just a beginning of that 40 hours module. We're just trying to shape you up that this is something where you will change your personality. This is a personality development program. And I say mediation is an alternative dispute resolution. Mediation is an appropriate dispute resolution. Mediation is an absolute dispute resolution. Because there is a finality of everything. You close down every litigation, every future litigation at one go. My best wishes to all of you. Time is short. We are here to conclude. Thank you organizers for having such a wonderful program. And I wish you all the best, that you become a good mediator, because mediators are required at every phase of life. You move out, you find somebody having a conflict, an argument, you can always jump into it and say, yes, let me mediate. Thank you so much. Thank you.
Good morning, dear friends. And with permission of Honorable Mr. Justice Purnendu Singh and Dr. Anshuman, who had laid the very nice foundation for what mediation is. So, quoting our Honorable Mr. Justice, Chief Justice of India, Honorable Mr. Justice Suryakant, mediation is just not ADR process, but constitutional value in itself. Mediation embodies the spirit of compassion, consensus, and social harmony. That is what lies at the heart of judicial delivery system. The judicial system delivers verdict, but mediation, it delivers the future. So with that, we had taken the pledge to be making mediation the first goal on our list. So I hope you all will be enrolled for the 40 hours very soon, and we will be making the mediation the most acceptable process for the dispute resolution. My apologies, the time is short, and that I only refer to this one social skill the mediator has to have, and it has to be inculcated. When we are in the judicial system, the party remains afar. They will not apologize because it will be the admission. It will be going against them. But in mediation, this social skills helps the mediator to take the parties from the adversarial to their own self-determined decisions. The apology plays the roles. How it is, where should it be, that all we will be dealing, or it will be the part of 40 hours. But for today, that one social skill, we have to remember that it is the plus point of mediation, with so many plus of it. With that, I rest my words. Thank you all. Thank you, the organizers. Thank you.
I thank the senior trainers from MCPC for having taken us through the nitty-gritties of mediation and their kind cooperation in the tight schedule of this session. We now come to a segment that adds a valuable international perspective to our discussion. It is my pleasure to introduce Ms. Chiara Tondini, International Disputes Counsel and Chief Operating Officer, M Disputes Italy, who is joining us online. Ms. Tondini, we are delighted to have you with us. The floor is yours.
Trust to the India International University of Legal Education and Research for this kind of invitation. Well, I had prepared a PowerPoint presentation, but in the interest of time, I will try to keep it as short as possible, and then I will avoid it, but I have just made it available to the organizers to the benefit of all that are interested in having it. In my short speech, I will focus on the features of mediating disputes in the framework of energy infrastructure projects, which is my area of expertise. Well, why are these disputes sensitive? Because they entail a very strategic, political, and human stakes. So, what are the features of this kind of disputes? Well, they are composed of very structured layers of stakeholders, where at the top we find the end user of the grid, which is usually represented by government or state-owned companies. What are the interests of those parties? The interests of these parties to provide energy security and political stability. Then we have a complex commercial ladder, let's say, of private operators, which begin with the project owners, which are represented usually by corporations that are entrusted by delivering engineering, procurement, and construction services to put the plant in operation, and then a cascade of smaller and smaller contractors, subcontractors, vendors, and suppliers, whose interests are those to make profits from the plant, from the construction of the plant. And this is very important for you mediators and lawyers, mediator advocates, to preserve and improve their commercial reputation. This is their asset, and they are very keen to preserve it. What is the particularity? Is that all these relationships are linked through independent but functionally intertwined contracts. One delay Can you hear me? Which will inevitably cause budget overrun and project impasses. And ultimately, all of this will impact energy security, will provoke social turmoil, and a consequent political fallout. Beside it, you will have local communities and NGOs, which will have employment expectations. As an example, when the plants are located in a developing region, there will be many people who will be expected to have a job from the project. And environmental and public health concerns, especially in specific kinds of energy plants, or housing concern when villagers are displaced pending the execution of the project or permanently. So you can imagine that a mediator entrusted in resolving or assisting the party in resolving such a complex dispute might and must handle and master many peculiar skills. One of the skills is recognizing fear. As an example, a subcontractor may fear being blacklisted by the contractor, or a community representative may fear retaliation for having filed a claim against the project owner. And be mindful that it is very, very frequent. All economic operators or local representatives fear retaliation or having to pay consequences for having filed the claim and for trying to see their rights or their interests protected. So how a mediator can cope with this? As an example, by using pre-mediation caucuses to separately assess with each of the parties that they feel safe to speak. And they have the duty to restructure or structure properly the project so that everybody sitting at the table can feel safe. Then they must have a culturally aware communication. Usually, energy infrastructure projects span parties from diverse countries and cultures, with vastly different communication norms and codes. As an example, you can have sitting at the table political representatives who will deploy a mostly diplomatic language. Or you have the private operators who will deploy business language. And representatives of local community who will speak very common language. So the mediator must invest in cultural fluency in order, and I reconnect to what the distinguished colleague have said earlier, in order to be able to recognize and to listen to the unsaid. I very like this expression. And then I'm going to the conclusion, but I'm keen to stress one aspect, which is very, very important, a very important skill that a mediator must develop, which is help the party to preserve their face-saving and shame management. In this kind of dispute, all the parties sitting at the table, but in all kinds of disputes, have to cope with their face-saving and to preserve their dignity. In this case, you will have at the table public representatives such as the ministries or state utilities and corporate executives who usually cannot afford to be seen losing face. Or they may have difficulties in explaining the compromise to their respective stakeholder. Remember that however powerful a representatives might be, they always have someone to whom they have to explain why they took this decision, why they accepted that settlement. And it is important that the mediator support the parties to make it acceptable or to frame a proposal in a way that it is acceptable by the other parties. I like to quote here the leading negotiation author that I strongly suggest to read, to all of you to read his books, who is William Ury, in his book Getting Past No, who said, build them a golden bridge, meaning without giving in to your interests, help or frame the proposal to the other parties in a way that it is easily acceptable by them. And the mediator, through listening to the unsaid by one party, can use this unsaid to help the other party to frame a proposal in a way that it is acceptable by the other party sitting at the table. And then ensure informed consent. Always make sure that all the parties sitting at the table have fully understood the terms of the agreement that is proposed and that is being discussed. This because you may have to face many power imbalances, power asymmetries. You may have sitting at the table a very powerful party and a smaller, weaker party. And you have to ensure that they are all at the same level, that no parties feel forced to accept an agreement and they fully understand what they are signing and what they are accepting. And then, last point, and I stop here in the interest of time, always team up with the lawyer, with the party's advocate, because mediators go nowhere without the collaboration of the lawyer sitting at the table and assisting the parties. I mean, I could speak for a whole day on how much there is a need to develop a culture for lawyers to learn to sit at the mediation table and how they must learn to assist their clients at the mediation table. The other distinguished colleague before me has already stressed how lawyers must shift their mindset to be from being adversarial to being collaborative. And I mean, the value of lawyers sitting at the mediation table is endless. So this is very important to develop. I will stop here by just reminding three key takeaways that I would be very happy you could take from my very short speech. So the first is that be mindful that in energy infrastructure projects, disputes are never isolated, but they are all intertwined and they have very sensitive fallout. Second, mediators and counsel must work as a team. This brings and adds immense value to the process. And third, that the goal is not just to settle, but to safeguard projects, to protect communities, and to preserve the parties' reputation. So I stop here and thank you for your attention.
Thank you, Ms. Tondeni, for those insightful and practical reflections. We truly appreciate you joining us from Italy. I now invite Honorable Shri P. Vishnuvardhan Reddy, Member Bar Council of India, to propose the vote of thanks.
Good afternoon, everyone. Today, mediation is an effective method of resolving disputes, growing in popularity as an alternative to the litigation, which can be expensive and lengthy. Over the past decade, mediation in India has undergone significant transformation marked by judicial recognition, legislative advancement and institutional development. I feel it's my privilege to propose the vote of thanks at the conclusion of the enriching training session 3 on mediation skills in sensitive disputes. First and foremost, on behalf of the Bar Council of India, the Bar Council of India Trust, Pearl Trust, I extend our deepest gratitude to Hon'ble Mr. Justice Purnendu Singh and Hon'ble Mr. Justice Dr. Anshuman for gracing this occasion, for sharing their invaluable judicial insights. Their words reinforce the judiciary's confidence in mediation as a constructive human mode of the dispute resolution. I sincerely thank the senior trainers from the Mediation and Conciliation Project Committee, the Supreme Court of India, Shri Surendra Singh, Srimati Pushpa Gupta, Shri Sachin Jain and Srimati Monica Jalota for their rigorous and practice-oriented training. We are also very grateful to Ms. Chaira Tanduni, an international dispute council, CEO of MD Disputes Italy, for joining online, sharing an international perspective on handling sensitive disputes. Her contribution reminded us that mediation principles transcend jurisdiction while remaining sensitive to the local context. My appreciation also goes to the leadership and faculty and staff of IIULER Goa for hosting this program with such efficiency and academic seriousness. I would also like to acknowledge the active participation of all delegates. Your encouragement, questions, enthusiasm are what truly give a life to program like this. I also say my deepest acknowledgements of gratitude to our Honorable BCI Chairman Sri Prabhakaran and also the BCI members Mr. Manoj Kumar, DK Sharma and also Mr. Patel and Mr. Ramireddy. As this session concludes, we move forwards the valedictory program. I hope the learning from today will transform into more effective, ethical and compensative mediation practice in the days to come. Thank you very much and I wish all continued learning and success in the coming days. Thank you very much.
Thank you, sir. This brings us to the conclusion of training session 3. On behalf of ILR and the organizing institutions, I thank our honorable judges, trainers and participants for making this session very enriching. May I request all participants to stay seated for the valedictory session as scheduled. Thank you all and I wish you a very good day ahead. Now I request our student volunteers to kindly take over and I request the audience to please participate in a quick conference poll. Thank you very much.
Good afternoon, everybody. I promise to not take more than 5 minutes. So since we have now come to the end of our 2 days mediation conference at ILR, for the past 2 days we have had multiple deliberations and discussions regarding mediation. So now as we come to a close, we have 3 questions prepared to help us understand what we now think and understand of mediation as a whole. So the questions will be displayed on the screen and you will have 10 seconds to scan the QR code that will be displayed on the screen and choose for the answer there. We request you all to kindly participate in this as it will be integral for the data collection which will then be presented in the report later on. Thank you. Just a reminder that you'll only have 10 seconds for every question and there's just 3 questions. Thank you. Just give us a moment, please. Multiple choice. We apologize for the technical inconvenience that was just caused. I'll just read out the questions and we can answer by a show of hands, if that's fine. Okay. So the first question is, when mediation fails, its most significant contribution is option A, clarifying interests beyond legal claims. Option 2, narrowing factual and legal disputes. Option 3, reframing party expectations. Option D, revealing limits of consensual justice. I'll just repeat the options once again. Option A, clarifying interests beyond legal claims. Option B, narrowing factual and legal disputes. Option C, reframing party expectations. Option D, revealing limits of consensual justice.
One question at a time.
Yeah, this please.
Now see, option A is
People who agree with option A, if they could just raise their hands. Okay. People who agree with option A to kindly raise their hands. Okay. Okay. The question was, when mediation fails, its most significant contribution is. Does anybody want me to repeat the options once again? Okay. I'll just repeat it once again. When mediation fails, its most significant contribution is option A, clarifying interests beyond legal claims. Option B, narrowing factual and legal disputes. Option C, reframing party expectations. Option D, revealing limits of consensual justice. Can I have a show of hands for option A, please? Thank you. Option B, that's narrowing factual and legal disputes. So we see 1, 2, 3, 4, 5, 6 people for that. Thank you. Option C, please. Thank you. And option D? Thank you so much. I'll move to the next question. Do you think promoting mediation has an adverse impact on the traditional litigation system with respect to advocates who are not trained in mediation? I'll repeat the question once again. Do you think promoting mediation has an adverse impact on the traditional litigation system with respect to advocates who are not trained in mediation? There's just two options, yes or no. Does anybody want me to repeat the question once again? Okay. Can we have a show of hands for people voting for yes? Okay, thank you. People voting for no? Thank you so much. We'll just move to the next question. That's also the last question. What primarily drives successful mediation outcomes in India? What primarily drives successful mediation outcomes in India? Option A, court-mandated structural incentives. Option B, party autonomy influenced by socio-cultural realities. Option C, professional competence of trained mediators. Option D, strategic conduct of legal representatives. I'll just repeat the options again. Option A, court-mandated structural incentives. Option B, party autonomy influenced by socio-cultural realities. Option C, professional competence of trained mediators. Option D, strategic conduct of legal representatives. Is everybody clear with the options in the question? Okay, can we have a raise of hands for option A, please? That was court-mandated structural incentives. Okay, thank you. Option B, party autonomy. Thank you. Option C, professional competence. Thank you. Option D, strategic conduct of legal representatives. Thank you so much. We've come to an end of the 3 questions that we had prepared. Thank you so much for participating in this. It is just for data collection for the rapporteuring after the conference. Thank you so much.